judgment. Item number 28, CRP 420 of 2010.
Petition allowed.
Item number 29, MSc Appeal 347 of 2017.
Appeal dismissed. However, award is modified.
Item number 30, MSc Appeal 465 2018.
Appeal dismissed. Award modified.
Item number 31, MSc Appeal 91 of 2020.
Dismissed. Award modified.
Item 32, RFA 35 of 2023.
Impugned judgment set aside and passed. Matter remanded to the learned trial court.
Item numbers 33 and 34, WPC 935 of 2023 and WPC 4110 of 2023.
Both the petitions allowed.
Item 35, WPC 2882 of 2023.
Petition allowed.
Item 36, WPC 4564 of 2024.
Petition dismissed.
Item 37, CRPIO 237 of 2025.
Petition allowed.
Item number 38, WPC 1547 of 2025.
Petition allowed.
Mention.
May I please, Your Lordship? Lordship, on contempt matter, Lordship, is a further matter. It was picked before vacation, but not listed today also, Lordship. Can you on 16, Lord?
Third matter.
Yes.
Okay.
May I please? I recommend item 2, Lord.
Yes.
Yes, in this case, respondent one has filed affidavit. I may be allowed to file counter.
Mr. Dutta.
My lord, in item number 5, my lord, the respondents have filed one affidavit in opposition as well as on IA, my lord.
No,
my lord,
item number 2.
Item 5, my lord. Two, my lord, my learned friend, Mr. M. Islam. I think matters from infrastructure side. I'm not very sure. Let it be. Well, let it fine.
Why?
My lord, within a week.
Within a week. Mr. Your name, please?
MS Law.
MS?
Alam.
MS Alam, learned counsel. For the respondent number?
6, Law.
Respondent number 6 submits that the petitioner herein has filed one additional affidavit.
Yes, Lord. Respondent 1 has filed.
Oh, respondent number 1.
1, yes, Lord.
Okay, respondent number 1 has filed one additional affidavit and he will file a reply to the same. And he press for listing the matter after a week. Fair allowed, press to list the matter after a week. Yes.
My lord, item number 5, my lord, my learned friend has filed, my lord, one affidavit in opposition as well as an IA. The IA has not come on record. In any case, my lord, we have to file a reply to both, my lord. So let it come after 2 weeks, my lord.
2 weeks.
2 weeks, my
Okay. Mr. M. Dutta, learned counsel court of petitioner, submits that the respondent herein has filed one additional affidavit in opposition and also one interlocutory application.
Yes,
Then he may be granted some time to file his response to the same. Here is allowed, SSL is not allowed to do it.
My lord, the registry may take the IA along with the records, my lord.
SSL also take the IA. What is the number?
IA number, my lord, my learned. My lord, number has, you see, number is not yet been, my lord, allotted, my lord.
We file on 26.
What is the filing number?
You provide the filing number?
Yes.
She'll provide. the-
Provide the file
Okay.
Apply the lodge.
May please, Your Lordship. I beg to mention item number 12, my lord, on behalf of Mr. N. Bora, my lord. He is out of station today, my lord. My lord, may be taken up, my lord, after a week, my lord.
Mr. R. Sharma, learned counsel appearing on behalf of Mr. N. Bora, learned counsel for the petitioner. Response listing the matter after
1 week.
1 week. Fair look.
Apply.
Item for motion, item 1,
May I please, Your Lordship? Lordship, kindly password for timely.
Wait.
My senior likes me enough. Right now.
items for admission, item 3, part admission.
May it please, Your Lordship?
Who is for the
Middle-
respondent? Secondary Education Department. So there was a direction to pay the subsistence allowance. Where is the document to show that you have paid the subsistence allowance?
Lordship, here there is one instruction to me.
What insert?
May I place it, Your Lordship?
No, direction was to release the subsistence allowance.
Yes, Your Lordship.
Whether you have released it or not.
No, Your Lordship, that has not been.
Why? We will take it up at 2 o'clock, you obtain inspection. Why subsistence allowance was not paid? 2 PM.
Yeah, Your Lordship, another, there is I have filed an interlocutory application bearing number 3151. There's some typographical mistake in the order, Your Lordship, in
Wait.
19/8/2025. Order dated 19/8/2025, Your Lordship,
We'll take it up at 2 o'clock.
Master of Lies.
Part admission.
Hey, please, Lordship. Lordship, last occasion, kindly peruse the order dated 10th of September.
In this regard, I have received one instruction from the department. And as per this instruction, my lord, the petitioner is not able to get the arrear salary as because he is delaying filing the writ petition, ma'am.
Pardon?
So I want to file affidavit, my lord. Yes.
Pardon?
My lord, the petitioner has not received the arrear salary as because he has not filed this writ petition the earliest, my lord, and after the lapse of 3 years, my lord.
No, Lordship, earlier also we had some litigation.
Yeah, this is my instruction. I have received from the department.
In earlier litigation also the petitioner claimed for the area and Lordship, area is clear, Lordship. Only incremental benefits are there. Area salary is not pending. Only
Incremental benefits.
incremental benefits, Lordship.
Here in the last, prior to last paragraph, that in view of, second last paragraph, in view of above, the present requisition was filed on in 2020.
This judgment will not help you. Because here the cause of action is recurring.
Hello, here cause of action is 1999 to 2019. ma'am.
After in every month, this cause of action arises. This decision will not help you.
So when we may be allowed to file our affidavit, my lord. This is it.
You may file your affidavit, but I don't think that it will help you. And if you were prolonging the litigation, then we will impose the cost. Cost and this interest upon the incremental benefit since the date of date of entitlement of the petitioner. This decision will not help you. There are several other decisions. Where the cause of action is recurring, then this will not help you. Elementary Education Department, who is appearing?
Last occasion GP.
I'm referring.
Hmm.
Lordship, here in the court list, our name is also not shown, so today it will be difficult for to.
Last occasion registry has directed to
Standing-
their name.
Standing council,
Hmm.
elementary. Name is.
Last occasion direction of the.
Lordship will list after 2 weeks, Lordship, I will obtain instruction. Lordship will list after 2 weeks, I will obtain instruction. Today, as because the name is not shown in the clause list.
Oh, why 2 weeks?
1 week, Lordship. Next
No,
week.
no. Afternoon, today
Lordship,
afternoon. You have been asked to obtain the instruction in respect of the letter dated 16/8/2025.
in that case, tomorrow, Lordship, tomorrow. Tomorrow, I will.
But it's Sarva learned counsel for the petition. Sarva Secretary to the department. And the E.H. Sarva learned counsel for the department. Sir, E.H. Sarva learned standing counsel for the elementary education department of state. He could not obtain the inspection. As the required by order dated 10/9/2025, then it tries to proceed the matter to court, so it's not available with data. Where is accordingly above, this is the reason that tomorrow.
Problem.
Highly obliged.
I think 7.
May it please your lordship. Lordship, in this case, instructions were sought for several times, lordship. Secondary education is there, lordship.
Mr. Sharma, where is the inspection?
After some time, my lord. Remove, sir.
Lordship.
May I please, your lordship? My lord, this matter is relating to family pension and other retirement benefits. My lord, during this pendency lordship, retirement benefit has already been given. And so far, a pension is concerned lordship. They have granted pension from June 2025. In fact, lordship, as per rule, it should be lordship from the date of application or from the date of notification of the amended provision lordship. If your lordship kindly come to page. Now only that part is remain relating to area part, area of pension. The pension has been granted with effect on 27/6/25.
And from who is that you are entitled to?
My lord. My lord.
From who is that you are entitled to?
My lord, that is lordship, that application lordship is not available with the petitioner when he was supplied, but one copy is there. If your lordship will kindly come to page 28, that some communication was made. In that even lordship, if my date of application is as not available the document, and these documents shows that page 28, 15/12/2022, subject unmarried daughter family pension of so and so petitioner. So, and this letter was issued in reference to the another letter dated 12/7/2022. So at best lordship, it may be if the date of application is not there, but perhaps in the office lordship, they can provide the information. We have lordship tried to get that copy, that when the application was filed and the application itself. And as per rule lordship, it should be from the date of application or from the date of notification. That notification was issued on 19/9/8/2018, page 16. Page 16, relevant, page 17, note 3, last part.
And you are not aware of on who is that you have filed the application.
Well, application was filed. After that process was made, and the only lordship, this communication lordship page 28, it shows that it may lordship from 2022. At best lordship, it may constitute from the date of letter dated 12/7/2022. And accurate lordship fact that can lordship, they can place it, the authority lordship. Petitioner tried to get that information lordship, she is unable to get that information.
Mr. Sharma? Last occasion?
We even tried to obtain instruction as regard that communication dated 26/5/2025.
No, that part is already done. I said,
And my instruction today I have received. According to that lordship, that petitioner has already received. With reference to subject cited above, in this connection, I would like to so and so, with reference to WPC number so and so, I have the honor to inform you that in pursuance to the Office of the Director of Pension Assam, letter dated 26/5/2025, the DO Sonitpur has already submitted the unmarried daughter pension proposal in respect of Susila Gaur, the petitioner in WPC number so and so, for according necessary approval. Accordingly, the unmarried daughter pension in respect of Sushil Akbar has already been finalized from the director of pension. That communication I had.
So are you receiving the same?
My lord, the pension, my instruction is that, Lordship, from the district of authority, she has been informed that amount has been credited, but she has to verify. Today she will get the information. She has not get any message.
That particular, it is the.
That part, Lordship, that part perhaps amount has already been received from Lordship for 3 months, June, July and August. And my Lordship claim now, it will be from the date of application, it should be. Whichever is a letter.
No, you could not state the date of your application. Mr.
Lord.
Sharma, can you obtain the instruction from the district elementary education officer Sonitpur when the application was filed?
Lordship,
When the petitioner filed the application there?
that particular instruction, I can obtain Lordship. Next.
Next week. Next week. In the meantime, Mr. Can
Lordship.
you verify whether the amount was credited in your account or
Lordship.
not credited for the product? So, Sir, you Sharma? Mr. P.N. Sharma, or this is the counsel for the department. Producing a letter dated 10/10/2025 of the Joint Director of Elementary Education, Assam, addressed to the Standing Council, Senior Standing Council, Guwahati High Court. So Sharma submits that the Director of Pension has already accorded approval for payment of pension in respect of the petitioner Sushil Akbar. And as per his information, the amount has been credited in the account of the petitioner. Mr. Khan, learned counsel for the petitioner, that is the submits that the petitioner has to verify the information. Now, as to whether the amount was credited in her account or not, and it is right that the matter may be listed on Wednesday,
Lordship. Next week, we get.
next week,
Next week, 22nd.
22nd. In the meantime,
Okay.
Mr. Sornosdel also obtained necessary instructions from the office of the District Elementary Education Officer Sonitpur as to when the petitioner has filed her application for granting family pension.
Yeah.
This accordingly on 22nd.
22nd.
August. Item 6.
May I please, the Lordship? My lord, in this matter, my lord, the peasant petitioner sees the widow, my lord. Her family pension has not been regularized, my lord. That's because during the life of my husband, lifetime, my lord, my husband retired on 2019, my lord. And, my lord, 2020, they issued an impunity order regarding one excess dwell, my lord. And thereafter, my lord, that impunity order, my lord, is still there, my lord, in force, my lord. My husband died on 27 January 2024, but they are not regularizing my family pension. My case is clearly covered by the judgment Rafiq Masi as well as the order passed by this honorable court. And last occasion, my lord, this honorable court directed to file affidavit to the private respondent as well as the government. The respondent 7 has filed affidavit and passed. There is no fault against my husband, my lord. So, my lord, why my family pension has been keeping pending till date, my lord? So, my matter may be disposed of, my lord.
Yes, secondary education department.
And it is almost 1 year, my lord.
I am for respondent number 7, headmaster. We have filed an affidavit.
Wait,
Affidavit filed on 27/5/2025.
affidavit in respect of
Respondent number 7
the
is the headmaster. I in charge headmaster.
In his affidavit, Milord says that there is no fault on my husband's part, Milord. There is a very meager amount, Milord, 56,000, Milord. For this purpose, my family pension has not been regularized till date. This matter is pending for the last 1 year, Milord. No response filed by the state. So may I pray, Milord, to dispose of the matter today itself, Milord. I am suffering, Milord. My family pension is due, Milord. If Lordship gives some more time, then 1 week time may be given to them, Milord. Next week, Lordship may fix the matter. Otherwise, Milord. And my case is
Lordship,
covered.
We have clarified, Lordship.
Yes.
It was a mistake in part of the earlier headmaster, Lordship. Page 52, we have clarified. Lordship may get page 20 as well as page 52 of my FD. Yes.
Beyond to that.
Page 20 of the registration may kindly be registered.
It's 22.
20 Lordship, of the repetition list.
Yes.
Lordship will get 1/4/2016 Lordship.
Hmm.
43,650. Then 1/7/2016, 44,960. Then 1/10/2016, 44,960 Lordship. Here there will be Lordship no addition. Same 1/7/2016, 1/10/2016. Now Lordship may kindly peruse page 52 of my FD. Page 52 of my FD. Lordship will get 1/7/2016.
Hmm.
44,960. Then 1/10/2016 after adding 3% SCPS benefit, 46,310. Here in page 20, Lordship, 1/7/2016 and 1/10/2016 is same. But we have given in a chart here in page 52 where there will be 3% SCPS benefit that did not add on by the earlier headmaster in fact. That is the problem crept up from here on.
And-
Now, finally, Lordship will get 1/7/2019, 49,140, but actually it could have been 50,620. Lordship.
What is the extent of the department?
That, Milord. Yes. No, this,
You have filed your affidavit?
No, Your Lordship, we have not filed.
No.
already, Milord, headmaster has stand his clear, Milord, no fault on my husband's part, Milord. Since the impine order issued on 2020-22, Milord. My husband died on 2024, 1st January, 27 January, Milord. Now, Milord, family pension, my case is pending for the last 1 year, despite this court repeatedly directed to them to file affidavit, but no response on their behalf, Milord. And respondent 7 has clarified my stand, Milord. So my pray, Milord, let they cannot recover the excess 12 my husband's salary, Milord, family pension, as well as, Milord, my family pension is deducted, and already this honorable court, considering the Rafiq Mas's case, Milord, I'd like to draw your lordship kind attention that 2 others I have enclosed here. Annexure 18, Milord, page 42. Similar, same direction I'm praying, Milord. Page 42 and paragraph 6, 7, and 8, Milord. Regarding excess drill and regularization of pension, Milord. Page 42 is the order, Milord, and order passed from page 44, serial paragraph 6, 7, and 8. And final order at para 8. And lordship will find that impugn order, Milord, at page 25, annexure 9. Page 25 and page 27. The earlier headmaster wrongly, Milord, that this given this statement at page 25, annexure 9. Wrongly calculated, Milord, this amount. Page 25. This is the first improved, my lord, statement of access dwell. Very next page, my lord, sorry, my lord, page 27 is the order issued to my husband, my lord, to the inspector of school, my lord. That is on 8/7/2022. That improved order is still in force. Therefore, they are not regularizing my family pension. That's because of this improved order, my lord. Page 27 and 2, my lord, serial number 2. The further access dwell assist with due and drawn statements should be duly certified by the HO regarding the whether there was any fault on the part of the pensioner for such wrong fixations, so that the matter on can be forwarded to the competent authority to waive recovery from the terms of tenure. This order is still there, my lord. So, my lord, there, as per the Rafiq Masih case, as per the direction of the Honorable Court, they cannot recover, and my family pension may be regularized, my lord. That is my only prayer.
Anybody for Mr. Deputy? Lordship, as per our instruction, on way back in 10/10/23, Your Lordship, to the inspector of Supri, we have communicated to set up pension proposal after waiving the necessary accounts. So, the respondent number 7 has filed an affidavit in opposition, where he admitted that some mistake has been committed by the earlier headmaster while fixing the salary of the petitioner. So in view of that admission, perhaps we can dispose of this.
Yes, we can close it with an outer limit to pay the pension to the
Regular.
petitioner with an outer limit of 2 months.
2 months.
Yes. We may issue direction to the concerned respondent.
And my lord, if any amount they have deducted, say maybe,
That is.
yes, my lord. They
Why?
cannot, the amount they have shown regarding excess trial, my lord. If they in the meantime they deducted from my salary, my lord, say maybe, yes, my lord.
Outer limit of 2 months.
Deep loveless.
May I please your say, this is also, my lord, that regarding deduction, my lord, excess royal. The petitioner's husband died, my lord. Family pension paper is pending, my lord. In view of, in my case, my lord, in view of the guideline given by the Rafiq Masih's case, recovery from employee when excess payment has been made for a period in excess of 5 years, because he died. That is from 118 to from 1118, some increment has been increased, my lord. And my lord, he's died on 2016. Now as 2014, my lord, is sought to be recovered. And my lord, he is a grade 3 employee, that also cannot be permissible. So my lord, lordship may dispose of, my lord, in view of the lordship or hard in the earlier item, my lord.
So Sarma,
Lordship, dispose of होता है. Here also that excess drawl is the main issue.
Clear, sir?
okay,
Any headmaster is a grade 3 employee. Obliged. May I please your lordship.
wait. It's Kakote. Arkat. Correct, okay.
She was there. I think Bahirot Gusen. Maybe after some time.
May it please your lordship. I require further 3 weeks' time to file a reply to that because the reply will come from France, your lordship, the embassy. So it's taking some time.
Reply will come from,
The French embassy, your lordship.
okay.
My
So-
lord, further 3 weeks' time may be granted, your lordship. I've talked to the client yesterday. They said that it will take some time because there are some procedure formality. The lordship will kindly grant me some.
My
3
lord,
weeks'
on 3rd of September, this, your lordship heard the matter in length, my lord. 3rd of September, kindly note, my lord. It is an application for, my lord, vacation of an order of implement, my lord. Your lordship, this honorable court, kindly produce the order of the implement order, your lordship. After going through the facts of the case, page number 17 of the IA, my lord, this honorable court found satisfied that respondent number 4 is a necessary party. You also pass the order, and my lord, only to delay the proceeding, this IA is filed. And after hearing on length on 3rd of November, 3rd of September, your lordship, and only a point raised by my friend that a decision of the Delhi High Court covered this case. 3rd of September, your lordship allowed 10 days time to go through the order only, the decision only, my lord. The decision did not cover this case, my lord. So my friend now came with a fresh plea of filing a reply. Where is the necessary to filing a reply, my lord, after hearing this matter in length, my lord, on 3rd of September? And the order challenging the IA is, my lord, page number 17 of the IA, my lord.
Hmm.
Whether this IA is maintainable, my lord, or not, your lordship may consider, my lord, this point, my lord.
Let him file his reply.
My lord, actually, my lord, in this matter, my lord, after filing my reply, your lordship has heard the matter on length of 3rd of September, my lord.
There are some things we need to dispute, your lordship. He has stated some statement, so that we need to dispute.
That may be
First of all,
disclosed, my lord, that may be disclosed at this point, my lord. What is
let
the-
me make my submission.
Yes,
You cannot speak.
make
Apuni
it.
se
One by
make
one.
us-
Your lordship, there are some issues which he has raised, which I need to counter, your lordship, first of all. Secondly, what my learned friend is saying is that it was heard in length. Your lordship, when the IA was filed for impleading me, I was impleaded without hearing me. And there was no reason cited that as why I need to be impleaded, your lordship. I'll get a certified copy of also that. I have a copy, but I'll get a certified copy of the IA, which is filed for my impleadment application. There is not even a single whisper as why I need to be impleaded.
It is mentioned in the order,
The
my lord.
only reasons they want to impede me is because of the fact that they does not want any more funds to come to the state of Assam. I am only an agency who is funding the forest department to carry out the biodiversity works. There is nothing, no role. I am not his employer. I have not appointed him. He might have some case against the forest department, but I am nowhere a party to that. So definitely I have to counter to that, your lordship.
My lord, my humble prayer is that, my lord, my friend may disclose what is the issue he has to reply, my lord, respond. That may be disclosed with this
I have
honorable court,
already
my lord.
stated, he has stated something which I need to file. I'll file it, he'll get a copy.
Nothing is there, my lord. My friend may disclose before the open court, my lord. What point he has to,
Okay, let him file his reply. Pardon me, sir, MC Kadi, Learned counsel for the opposite party number 1. You are the applicant here.
Yes, sir.
The
No, I have been
original-
implemented as a respondent number 4.
So Sina submits that it has been granted some time to file.
3 weeks time.
Oh no,
3
Already-
weeks time, your lordship.
IA is filed by you.
Yes, your lordship. They have filed a reply to that IA. I need to counter, there are some facts.
Okay, Mr. Arsena learned counsel for the applicant submits that the opposite party hearing had filed affidavit in opposition, and he will file counter to the same, and as for granting 3 weeks time, however, 2 weeks time is granted, that is the matter on fixated
On 29th October.
as ordered.
Running at 27.
May I please have a seat? On last occasions, I prayed to obtain instructions whether the matter may be referred to mediation center.
Mm.
I have get instructions, but the proportion is not ready for mediation center. So let's say kindly fix the matter for final discussion after 2 weeks.
After 4 weeks.
2 weeks.
Wait,
Today itself, it has been fixed in the admission column. It's in the,
it seemed not.
not for mediation. It's
Not for.
maybe next week if possible, my lord.
Of the Code of Ethics of Ethics are
Huh?
calculated that of the Code of Ethics number 2, 3, 4, 6, 7, 8, and 9.
6 November. November 6.
November 6. So next week, second week of November. That's of this. Kakuti obstructions that the parties are not willing to put the matter in mediation. Then as such, he prays for listing the matter for final hearing and disposal. There is a long place to salvage the matter on
6 November.
next second.
Second week of
Second week of November.
second week of November, also 6 November.
Much obliged, my lord.
Item 11.
Inspector, Executive.
Then
But this is a case of special family pension. I am appearing on behalf of Mr. B. Sharma because there is some urgency here, my lord. On the last occasion, your lordship was pleased to direct the respondents to get the instruction. This is an order of 2015, 11/6/2015. Operative portion, my lord, will find page 12. It was a simple exercise that was directed to be done, but it took them almost
is number
12. In view of the above, this writ petition stands allowed by directing the respondent number 5 and 6 to redo the exercise of computing the special family pension amount of the petitioner by adhering to the spirit of the OM dated so and so in letter and spirit. The exercise which the respondent 5 and 6 are required to take, as indicated above, shall be completed in a period of 4 weeks from the date of receipt of a certified copy of this order. While redoing the exercise in terms of the above, the respondent number 5 and 6 shall also take into consideration the OM dated OM of conversion of 50% dearness relief into dearness pension issued under the provisions of Assam Service Revision of Payrolls 2010. Till date, my lord, nothing has been done. And on the last occasion, your lordship was pleased to grant them time to get the instruction. 10 years, my lord, the contempt is surviving.
is the deputy.
Yes, your lordship. Lordship, may I, with the consent of this one, may I read the instruction, your lordship? The matter is related to non-payment of special family pension to Sarifa Begum, wife of late Habibur Z. Rahman in terms of government OM dated 26/8/1985, who was serving as a LDA at DP Milan High School in the district of Nalbari, when he succumbed to bullet injuries on account of extremist violence. From the Honorable High Court's order dated 11/6/15, it has been learned that the petitioner was granted special family pension by the Deputy Secretary to the Government of Assam Education Department by order dated 27/12/1985. And accordingly, this directorate had issued PPO by fixing her pension at rupees such and such per month as special pension, 2661, for the period with effect from 4/11/1992 to 31/12/2009.
That is until the date on which the deceased government employee would have attained the age of superannuation. Later on, the pay of the petitioner has been revised at rupees 2811 per month on account of increase of interim relief and medical allowances. But due to non-availability of the PPO details, first ex gratia sanction order of government and detailed drawal records of family pension by the petitioner, the undersigned white letter dated white letter number dated such and such 9/8/24 and reminder letter number such and such dated 3/10/24 copies and has requested the Director of Secondary Education Assam as well as the concerned petitioner to provide the required records documents through the concerned head of the this directorate for taking further needful action as per direction of Honorable High Court. But in this regards, no reply has been received by this directorate from the concerned authority till date, which this communication was on 29/11/2024. So let the secondary education, Director of Secondary Education, and if the petitioner, if he is in the position, let him furnish the concerned details that is sought by the directorate, by the Director of Pension.
The contentions which has been said in the this letter, that was a part of the proceeding in the original order of the writ petition. That so and so amount was pension fixed, then it was revised. And after that, after considering those things, this order was passed. এখন কোন ইস্যু বলছে?
Director of Head of the department by Model Department by এগুলি
If after 10 years they say that we don't have documents, if paras
So Devi,
yes, your lordship.
so the order is passed against you. You were to comply with it. So we are concerned with you only. You comply with it. You obtain the required information from the concerned department. You cannot sit over the matter. Already 10 years elapsed.
only thing is that from 92 to 2009, the pension remains static. This honorable court has held, it cannot, para 7 of the order, this honorable court has observed that pension cannot remain static from 1992 to 2009. So you have to take into account the 50% DNS allowance which was available to the employee and recalculate the thing. That is the only conclusion this honorable court derived. It is completely a clear case
Well,
of contempt, my lord.
May I, your lordship? So lordship, since these other respondents are also there, as they have represented your lord. So the concern does those inputs which the Director of Pension have sought for. So may they be instructed to furnish the same alone. We'll do that as it is. If they furnishes the same, the Director is
No,
Good.
here secondary
The-
education department is not a party.
Lord, the direction was to respondent number 5 and 6, Commissioner and Secretary Pension, Public Grievance, Dispur, and Directorate of Pension. So since it's a direction to them, they are required to comply with the directions. How they do it, my lord, what documents they get from the education department or secondary education department is their lookout. It cannot go on like this. And it's a case of special family pension to a widow, old widow.
Tell me whether this order is available in the office of the respondent number 5 and 6. Whether they have gone through the direction issued in paragraph number 9.
Lordship, in that case, I pray your lordship that may date be fixed on by Friday or next week. I shall take the matter, take up the matter with them.
Direction is simple. You are directed to recalculate the.
Yes. Yes, sir.
So why these documents are required? Nothing. TP order is already there.
Let this be on the come day after tomorrow, your lord.
Day after tomorrow, yes. Wednesday.
Even instruction from
Third.
the secretary.
Sector does alternate. Council appearing on behalf of Mr. D. Sarma, alternate for the petition. And also heard Mr. Devi, alternate for the
Together, full.
alternate of not number 5 and 6. Mr. Devi has produced a letter dated 29/11/2024 issued by the Director of Pension and submits that
Nine.
of documents are not available. The office of the respondent number 5.
Nine, one copy. Madam, one is. Take the full specific. Renew to connotation.
Of the respondent number 4. Respondent number 4. For which the exercise as directed by this court in the paragraph number 9 of the order dated 16. Eleven 6/2015 could not be carried out as a he price for issuing direction to the standing council of the secretary education department to make the required document available. However, going to the order dated 11/6/2015, specifically paragraph number 9, it appears that direction was issued to the respondent number 5 and 6 to redo the exercise of computing the family special family pension amount to the petitioner by adhering to the office memorandum dated 26/8/1985 in letter and spirit. That further there was direction that the exercise shall be carried out within a period of 4 weeks of the date of receipt of certified copy of this order. But since the date of passing the order on 11/6/2015, more than 10 years elapsed, and till then the order has not been complied with. That is, Mr. Devi learned counsel for the respondent number. You will put 4 and 5.
Lordship, there's some development, your lord. Lordship, I have some instruction in this case that the inspector of school Nalbari has already forwarded the relevant documents to the director of pension on 15/9/2025, Lordship. That the photocopy of the pension payment order along with the details of PPO. I have given, I have given that. That is the instruction. That's a copy.
Then you want to, Mr. Devri,
Yeah.
you do the exercise
I've
as per direction of this court.
The focus of the perspective there. So, so Lordship, 15/9/25. Yes, on day after tomorrow, I shall come up with the update. It will be copy, sir.
Equal to line. So that is this is Mr. Sisti, SMT Sisti, Learned Islamic Local Product Secondary Education Department. That for each letter dated 15/9/2025.
Yeah.
Addressed to the Director of
Will you
Pension by the Inspector of School NPC Nampally, and submits that the required document has have already been furnished to the Director of Pension by letter dated 15/9/2025. In view of Mr. Devri, Learned Counsel for the contender submits that the matter may be listed day after tomorrow so as to enable him to obtain up-to-date instruction. Thereabout, if you submit them after day after tomorrow. Documents for this for the board today shall be marked as an exert X and Y and we take to the record.
Obliged. Highly. Itu rakilang number. Mo diye sudah photocopy.
এটা ফটোকপি করে থাকি।
You will find the direction as page 12 million. This is the speaking order.
Ali,
Lordship.
you can furnish with a copy of this or?
Yes, Lordship, just now, my lord, I have got.
Page 12 is the direction. Paragraph 5.
Type copy negate.
No, it's digital. Still fine. Easy.
12.
So you go through the order
Lordship.
and you obtain instruction and let this court know day after tomorrow.
Lordship.
Mr. Arakli, Learned Counsel for the petitioner and Sir Posik, Learned Counsel for the Learned Counsel for the contender. Sir Posik has produced one order
Dated 12/10/25.
dated 12/10/2025 passed by the Director Secondary Education. Secondary or elementary? Elementary education. Elementary education department. And submits that in terms of the direction issued by this court in paragraph number 5 of the order dated 23/5/2022 has been complied with. A copy of the letter and a copy of the order is furnished to Mr. Ali, Learned Counsel for the petitioner, so as to enable him to obtain instruction. This is a list of matter day after tomorrow.
Public.
The speaking order produced before the court today by Mr. Posik and the part F and XRX that shall be taken to the report.
Okay. My lord, the Lordship may kindly see the order dated 13/8/2025 of Lojima Good report file.
Order dated 13.
13/8/2025.
Okay.
Actually, service in respect to Rasmus 12 was completed. However, this novel asked me to take justice service among the Rasmus number 12. We have taken justice service, but he refused to accept it, my lord. So service in respect of 12 is also complete. All other Rasmus all are completed. my lord. Then, my lord, ordered Lozama could report dated 17/11/2024, my lord.
So, service upon all the
Yes, yes, complete.
have been completed.
But if you also say last order passed by this noble court, there is some misunderstanding. Last order, my lord. I have taken justice service, and I mentioned, submitted that he refused to accept the notice, and his notice has also been accepted by the respondent number 7. So actually, there is no usual service thereafter, my lord. So service is completed. my lord.
Whether you have filed your affidavit?
No file, my lord. So, my lord, old matter is very old. So for that matter, I'll be given within 1 week. They have filed a reply. my lord.
Interested to file your affidavit or not?
But we will file our affidavit, Your Lordship.
10 and 13 file their affidavit.
Paragraph 13 file. Paragraph 13 and 10, the file. Very peculiar, my lord. That
They have made Lordate Council for the petitioner and Miss Lordate Standing Council for the Secretary Education Department. Office note dated 13/8/2025. Indicates that service upon respondent number 6, 7, 8, 9, 10, and 12 completed. Is P. Lordate Council Standing Council for the respondent is affidavit. There is allowed as a separate subject on third week of November. Third week. Third week.
13 number. Hey, number 12. 12 number. number लिखे ना.
Item 15, I need some little accommodation because as swiftly as you are requiring in this case, records are with him. If you have personal difficulty, she is not present today. For few days, you will not be able to. Lottie may can figure on Friday, next Friday, I will try to get the records also and get the instruction also, Lottie.
Okay.
This Friday.
Third is our Islam Lordate Council for the petition. And also our SMP60 appearing on behalf of Ms. Sophia Lordate. Standing Council for the respondent elementary department. Because it submits that the matter assigned to Ms. L. Sophia, but due to some personal difficulty, it could not appear for the court. And the price for this the matter on Friday, so it's going to go into obtain necessary instruction. There is a lot principal is the matter of Friday.
Yes, Lord.
Let kindly keep it part out, madam.
17
There is no question of taking part. I will get the instruction, Lottie. Normally, I used to get the instruction. Let it come on Friday, Lottie.
Yes, sir.
Item 16.
Item 16 is it a Yes, first time it is listed after issuance of notice lawsuit. Notice was issued on 12/1/24. And after that lawsuit, this is for the first time. This lawsuit may kindly give us 2 weeks time to get the instruction lawsuit. I have already informed the respondent authorities regarding this case lawsuit.
My lord, my learned friend's name may be reflected on you.
And respondent number 3, he is no longer holding that post of post lawsuit. If I 3 to come. Yes, 3 is no longer holding the post lawsuit. So I have informed the present incumbent. Let him include in the meantime lawsuit. Operator Diva kindly.
Pardon, Mr. A. Formuya, Lord at Council for the petitioner, the sub-existing. Lord at Council, appearing for the respondent number 1 and 2.
Yes, lawsuit.
One and two. Mr. 60 has pointed out that the contemptor number 3 is no longer holding the post. And as such, there is a requirement of stating the present incumbent with a petition. Accordingly, it is provided that Mr. Formuya, Lord at Council for the petitioner said take necessary steps and we have some present incumbent. Of the inspector, office of the inspector of the school case, DC, I let that be. Mr. 60 further submits said he may be granted 2 weeks time to obtain necessary instruction. There is accordingly allowed this the matter after 2 weeks.
Yes, Lord.
In the meantime, Mr. Formuya, Lord at Council for the petitioners, and take necessary step to bring the record the present incumbent of contemptor number 3.
My lord, kindly, my lord, my learned friend's name may be reflected, my lord, in the call.
Okay, this is reflect the name of Mr. Assisting. It at all this.
Yes, obliged.
So, contemptor number, you will represent the
Yes, Lord. I have also only mind for the department lawsuit.
order.
Oblige, your Lord.
Oblige.
17.
So 60, the information is available with you. This matter.
Yes, proceed. I have received some instruction lawsuit, but I couldn't go through it. Lawsuit may kindly. Yes. I have received a letter.
The petitioner is also absent. Let it be day after tomorrow.
Or next week lawsuit. In the meantime, I'll get the, because I have received a letter written from the director to secretary. So I have to receive the information from the secretary. So next week, can you just lawsuit?
None appears for the petitioner on call, however, Mr. SM is in product the present. When he applies for this in the matter after a week. So as to enable him to obtain up to date instruction. There is a lot, this is a information next Monday. Monday is only there.
Monday.
When?
Right. Apply for.
Item 18.
None appears for the petitioner applicant on call. Thank you. Although, you are for?
And for the secondary department,
It's directly for secretary division department, and you? Is your name, please? R.R. Saikya, Learned Counsel, appearing on behalf of Mr. S. Kennedy. Learned Counsel for the respondent number 6. 4, respondent number 4, present. Then, madam, you are here? 4. Respondent number 6. Yes, Lily Burman, Learned Counsel, number 6. This is a matter after a week in the event of subsequent non-representation of the applicant, appropriate orders are followed.
Sorry.
You are the applicant here?
Yes, madam.
Okay, okay.
Look, miscellaneous application is in file, my lord, for granting, my lord, the leave to file a review application, my lord. your under the orders dated 24/9/2024, my lord. No, dispute between, my lord, the governing body and, my lord, headmaster, my lord. My lord, some negotiations also going on, my lord, to recover the amount, my lord.
What is the relief being claimed in this application?
My lord, leave to file a review application, my lord. My lord, that the applicant was not a party in, my lord, proceeding, my lord. So, my lord, that's why my leave application isn't filed, my lord, to file a review application, my lord, against the order dated 24/9/2024, my lord.
And who are you?
My lord, I'm the, my lord, school management committee, my lord.
School management committee.
Yes, my lord.
And how you were affected by this order?
My lord, I'm the, my lord, body constituted by the government, my lord, to look after the development of the school, my lord.
Hmm.
And, my lord, the allegation is that, my lord, that the retired headmaster, my lord, he has currently, my lord, misappropriated a huge amount of money. And it is supported by the audit report also, my lord, amounting rupees, my lord, 21 lakhs, my lord.
No, there is a direction to held up 25% of the retirement.
Yes, my lord. My lord, but that amount will not, my lord, meet the, my lord, whole recovery, my lord. And, my lord, that one opposite party has already, my lord, given an undertaking, my lord, to pay the amount, my lord. My lord, that's some negotiation. That's why, my lord, some public meeting was held, my lord, and negotiation is going on, my lord. And, my lord, in the proceeding also, my lord, that, my lord, the opposite party has submitted that, my lord, they have not received the, my lord, provisional pension also, but practically it is not correct, my lord. Till that, my lord, he is receiving that, my provisional pension, my lord. So, my lord, it will come in the, my lord, review application. If lordship kindly allowed to file that. We have already filed it, but registration. No.
So whether notice was served upon respondent number 7.
No, my lord. But, after giving, if lordship, kindly allow, leave me, then we may serve the copy, man.
No, can we grant you permission to file the review application? To grant leave to
My
you
lord,
file the application without hearing him.
no, my lord, I am, my practical, I was not in a party, my lord, in the read proceeding. Though I was a necessary party, but I was not involved, my lord, implicated as party respondent in the read proceeding, my lord. Or lordship, directly issue a notice, and then we may send it to the registered post also, to the opposite party.
And let notice go then,
Yes, ma'am.
or later on, Mr. A.K. Sharma, learned counsel for the appear. At some extent, this interlocutory application is filed for granting leave to file a review application against the order dated 24/9/2024, passed in WPC number 630 of 2024. Mr. Sharma, learned counsel for the applicant, submits that by order dated 24/9/2024, WPC number 632 of 2024 was disposed of by this court. And that the present applicant was not arraigned as a party in the aforementioned proceeding. Arraigned proceeding, and the order was passed without hearing the petitioner, without hearing the present applicant. And that the respondent number 7 has appraisal an amount of rupees
21 lakhs.
21 lakh. 21 lakh. And if the petitioner, no, if the respondent number 7 is allowed to withdraw his pension and pensionary benefit, then serious prejudice will be caused to the present applicant. And as such, there is a requirement of reviewing the order dated 24/9/2024, and accordingly he tries for granting leave to the applicant to file a review petition against the order dated 24/9/2024. The submission of Mr. Sharma, learned counsel for the applicant, is further consideration that is itself notice be put to the respondent. Opposite parties by registered post with AD and also by itself also. Place the matter after. Sorry.
The completion. Oblige.
Here I'm praying for some accommodation, madam. But my grants 10 days time to obtain the instruction, madam.
May please your lordship, time password for time being,
Who will appear?
L Gogoi is on legs.
So the informations are not available.
Not available. 10 days time will be granted. madam.
One week. Hard miss. Your name?
Anju Buragonghai.
Joe Buragon, learned counsel appearing on behalf of the Telco, learned for the petitioner. Also, hard Katonier, learned the counsel for the content of the happens that it has been granted 10 days time to obtain instruction. How about 1 week time is granted to answer? Katonier to obtain necessary effect. This is the matter of it.
24th of
Oblige.
Item 20, we have complied. We have already received that amount and he has received, the petitioner also received.
Lordship already come.
Okay.
Hard Mr. Laskar,
My lord.
learned counsel for the petitioner. And then Laskar, learned counsel for the petitioner, and Mr. FM.
1 and 2, Lordship.
Learned. For the 1 and 2, that's contemptor number 1 and contemptor Solia.
For contender number. Respondent number 3, I'll be okay.
Respondent number 3.
Yes.
Respondent number 3. The SISTI has produced one order dated 10 of October 2025 and submits that the order of this court dated. Is the date
Lordship, order dated, Lordship,
72?
25.
72/25.
72/2025 has already been complied with. Mr. Lawford, learned for the petitioner also submits that the order has been complied with by the respondent. Contemptors and assess based on matter may be closed accordingly, taking note of the submission of learning for both. This contempt case number 302 of 2025 stands closed. The letter for the court today shall be marked as X that we take to the record.
Obliged.
As per official 1999, pleadings are complete. Respondent 7 is not appearing till date.
Pleadings completed.
May I pray, letter will come up for admission in the next week.
Admission.
Yes. Today, letter has come up for order.
Heard Mr. F. of learned of the court of it. That Mr. P. Hazarika learned.
I am appearing for
Mr. A. Sharma for amendment number 7. That is Soikia, R. Soikia for respondent number 5. Number 5. Any other respondent? Mr. Solia for 2 and 6. Ms. Bowman for 1 and 3. Mr. Sharma, you are?
Respondent number 7.
Respondent number 7. 3. It is submitted at the bar that pleadings have been completed. It is petition that the matter
My lord,
may be listed for admission hearing.
My lord.
Can it-
List the matter for admission hearing.
lordship date, lordship, can it be on Friday, lordship, on next, lordship, after 20, lordship, I will be not there, lordship. Can be 17, lordship. But very,
3rd week of November.
My lord.
3rd week of November.
Obliged.
আইটো প্লেস নকৰা মই চাই যাওঁ আইটো প্লেস কৰাৰ কথা নাই আৰু আই এটা ফাইল কৰা দেখিলো 22 নালাগে ডাইৰেক্ট this is a review petition preferred by the state, my lord. They have filed an IA also, but I'm placing the main review petition today, my lord. We have filed this review petition seeking review of the order dated, my lord, 23/2/2021, whereby, my lord, direction was issued to give the benefit of provincialization to the petitioner under the 2011 Act. It has been declared that, my lord, the service of the petitioner was deemed to have been provincialized under section 4(1) of the Act of 2011. So accordingly, direction was issued to give the consequential benefit. So while processing the case of the petitioner, we found some anomalies, my lord, regarding her initial continuation of service. So that aspect would not be brought before this honorable court while deciding the writ petition. That is why we have filed this review petition, my lord. My lord, may I kindly come to the impugn order at page 35.
Yes.
May I read the relevant part, my lord? Paragraph 2. The petitioner was appointed as an assistant teacher arts in Savitri Bharali High School, Guwahati, as per the order dated 27/6/2006 of the secretary headmaster of the Savitri Bharali High School, and accordingly he joined on 28/6/2006. It is stated that the appointment of the petitioner was pursuant to an advertisement dated 25/5/2006 issued by the school concerned.
As per the staffing pattern, the petitioner happens to be the third assistant teacher's arts after Srimoti Korobi Mishra and Srimoti Pujolata Rabha. For the purpose of provincialization under the so-and-so Act of 2011, initially the Act provided for provincialization of 2 assistant teachers' arts, and accordingly the petitioner did not find place in the process of provincialization being the third assistant teachers. But there was an amendment brought to the Act of 2011 in the year 2012, whereby the number of teachers in respect of the category of school to which the respondent number 6 belongs was increased to 3. If 3 assistant teachers are to be provincialized in order of seniority, the petitioner comes within the requirement of being provincialized. In the initial document, as the authorities were considering provincialization of only 2 teachers, the name of the petitioner did not find place. But the subsequent pro forma for information on provincialization of venture educational institution in respect of respondent number 6 school, the name of the petitioner is shown to be the third assistant teacher arts, but in the remark colon, it is being stated held up. Being aggrieved in not being provincialized, the petitioner approached this court by way of writ petition number so-and-so, which was given a final consideration by the order dated 3/11/2014, by which the petitioner was required to submit a representation before the authorities. Pursuant to the representation, the order dated 21/9/2015 was passed, wherein a conclusion was arrived that from the record produced by the authorities, the name of the petitioner as third assistant teacher was not found. Be that as it may, the petitioner again approached this court by way of so-and-so, which was given a final consideration by the order dated 4/4/2016, by which the Director of Secondary Education was directed to reconsider the case of the petitioner for provincialization under the Act of 2011. With reference to the earlier judgment dated 4/4/2016 passed in so-and-so, although there was a specific direction to the Director, the matter was not proceeded further. In the meantime, the Act of 2011 was set aside by the judgment of this court dated so-and-so, passed in so-and-so. Subsequently, a review was also instituted against the said judgment, and the review petition number so-and-so was disposed of on 21/1/2017, wherein it was provided that all actions that were taken pursuant to the Act of 2011 would survive, even though the Act had been struck down. From the said point of view, we are now required to consider as to when the requirement of Act of 2011 was carried forwarded by the respondents, whether the petitioner was included in the list of teachers for provincialization. We have already taken note of the pro forma for information on provincialization, which contains the name of the petitioner as third assistant teachers arts in respect of Savitri Bharali High School, which has been signed by the authorities, including the Inspector of Schools Guwahati, Additional Deputy Commissioner Kamrup, Chairman of the District Scrutiny Committee, and all the other such members of the District Scrutiny Committee. And pro forma for information on provincialization is noted to be dated 18/11/2013. We have to understand that as on 18/11/2013, the respondent authorities had arrived at their own conclusion that the petitioner was the third assistant teachers in the Savitri Bharali High School. As regards the entitlement of the provincialization by the petitioner, we take note that although the Act of 2011 has been struck down in the meantime, but Section 4(1) of the Act provides that the services of the employees of all venture educational institutions under Section 3 of the Act shall be deemed to have been provincialized on the date of coming into force of the Act. We have also taken note that, as notified, the Act of 2011 came into force on 1/1/2013. A reading of Section 4(1) of the Act of 2011 goes to show that whichever teacher was found to have been eligible as per Section 3 of the Act are deemed to have been provincialized from the date when the Act came into force, meaning thereby from 1/1/2013. The materials placed before the court, particularly the pro forma for information on provincialization annexed at page 95 of the petition, clearly goes to show that the petitioner was found to be the third assistant teacher arts of the school concerned, and the provisions of Section 3 of the Act of 2011 as amended in 2012 provides for 3 assistant teachers arts in order of seniority to be entitled for provincialization. In other words, when the respondent authorities had arrived at their own conclusion that the petitioner is the third teacher arts in the concerned school and the 3 posts of assistant are to be provincialized, it has to be understood that by operation of law under Section 4(1) of the Act of 2011, the services of the petitioner had deemed to have been provincialized with effect from 1/1/2013. Such deemed provincialization under the operation of law cannot deprive the petitioner merely because the respondent has failed in their duties to pass any other consequential order of provincialization, which otherwise also would not be material, as it is a provincialization by operation of law and not by any consequential order to be passed by the authorities. From the said point of view, we declare that the services of the petitioner was deemed to have been provincialized under section 4(1) of the Act of 2011. As per the conclusion arrived at by the respondents that he was the third assistant teacher arch of the school concerned under section 3 of the Act of 2011. The third teacher is entitled to be provincialized. All consequential benefits of provincialization that the petitioner may be entitled shall be provided for her within a period of 2 months from the date of receipt of a certified copy of this order. We also take note that as required under section 10(4), the government of Assam has also approved the provincialization of the petitioner. So accordingly, the writ petition stands allowed. So thereafter, my lord, we have sought a report from the inspector of schools, my lord. Well, 12.
Okay, we'll resume after 5 minutes. Mr. Khatani here,
Yes, my lord.
what is the ground for review of this order?
Yes, my lord. I'm coming to that, my lord.
Hmm.
There is an observation by this honorable court that her name was subsequently forwarded when the act was amended, and it was provided that maximum number of teachers increased to 3, my lord. Then her name was forwarded by the headmaster of the school. So while we have examined the case, we found that her name was not forwarded by the headmaster of the school, my lord. That is the document we have annexed in this review petition, my lord. Well, kindly come to page, the subsequent page, my lord. Page 39. That is the only ground, my lord. Page 39. This is a letter written by the inspector of school to the director of secondary education, my lord. With reference to the subject cited above, I have the honor to state that regarding submission of report on the matter of provincialization of services of the petitioners, Chandrama Devi, assistant teacher arts, Savitri Bharali High School, Odalbakra, so and so, I have the honor to submit herewith the copies of proposal submitted by the head of the institution for provincialization of teaching and non-teaching staff of his institution under the Act of so and so, so and so, in Annex 2, copy of the letter of approval of the then Inspector of Schools, Kamrup District Circle, Guwahati in Annex 3, and a copy of the recommendation of the District Scrutiny Committee Annex 4 for favor of your kind consideration, information, and necessary action. It is for kind information to you that the name of the petitioner so and so has not been found in any of the aforesaid annexes. So here, my lord, this is the letter of page 40, 8/12/2011. This is the first proposal, my lord, submitted by the headmaster of the school to the inspector of school, my lord. I have the honor to inform you that I found an advertisement so and so. So, sir, I have submitted the application for provision of services of employees of high school along with all relevant documents, individuals' documents of all teaching and non-teaching staff. So, my lord, may kindly come to page 44. This is the first pro forma, my lord. Page 44. Category of staff, headmaster, then assistant teacher, BA, BCom, single section, my lord. Here, Korobi Mishra and Kuzolota Rabha. In the first pro forma, my lord, the name of the writ petitioner was not there. So during that time, my lord, only 2 teachers are eligible. So subsequently, in the year 2012, in the month of August, amendment was made, my lord. Subsequently, pro forma was sent, another pro forma was sent, but in that pro forma also, my lord, her name was not there. Page 52. Page 52, my lord. It was sent on 27/9/2012, after the amendment, my lord.
Here also her name is not there.
Her name is not there. So this fact would not be brought before this honorable court, my lord. But she relied on another document, my lord. Page 53 is a type copy and 55 is the original copy. It is dated 26/9/2012. It was issued before the original document, my lord.
Page number?
Page 55, the original one, my lord. In this pro forma, her name was there, my lord. Mishra, Pujolata Rabha, and then Sondrama Devi.
Hmm.
This is signed on 26/9/2012. Whereas, my lord, the headmaster sent it on 27/9/2012, my lord. So she relied on a document which,
Whether it is page number 39,
yes, my lord.
page number 44,
Yes, my lord.
and page number 50, 14, no, 55,
Yes, my lord.
52.
Yes, my lord.
These three documents were placed before the court.
That was placed, my lord. No, my lord. These documents were not placed before this honorable court, my lord. But she relied on a document, page 55 document, which was signed on 26/9/2012, wherein her name was there, my lord. On the basis of this document, my lord, the order was passed. That her name was recommended by the, forwarded by the head of the institution, and subsequently it was recommended by the district scrutiny committee. That was the finding of this honorable court, my lord. But my lord, kindly come to page,
So, do you have any doubt about this page number 55?
yes, my lord. Yes, my lord. That is why, my lord, we have prepared this review petition, my lord, because we are, the headmaster sent this document, page number 52 document, my lord, as a pro forma, revised pro forma, my lord. And the forwarding letter is at page 49.
Hmm.
That is dated 27/9/2012.
So, what materials are there to show that this is not the original document? Page number 55.
So this 55 document was never sent, my lord, by the headmaster of the school. In fact, though headmaster filed an affidavit, but that was also not disclosed in the affidavit in the writ petition stage, my lord.
Do you have filed your affidavit in opposition?
No, my
with
lord, the headmaster of the school, he filed an affidavit in the writ proceeding, my lord. But that there also it was not disclosed.
Not disclosed.
Not disclosed, my
Why,
lord.
why it could not be disclosed?
Well, because headmaster affidavit is, well, okay. In the affidavit filed by the headmaster, my lord, they have just, he stated that her name was forwarded by the headmaster after the amendment. But the document was not annexed with this.
So that is why. What is the explanation for the same? Because you have to explain it, and unless the explanation is found to be satisfactory, this is not the ground for review.
No, my lord. Headmaster just filed an affidavit stating that her name was forwarded by him
Hmm.
after the amendment.
Hmm.
But original pro forma was not annexed. with the-
Why these documents are not part of the, not made part of the affidavit?
Because
That
that,
explanation should be there.
my lord, that affidavit was filed by the headmaster, my lord.
Hmm.
Not by the department. So he has not annexed during the proceeding stage, my lord.
Hmm.
Subsequently, when we process
you
the,
have, you have filed your affidavit.
as per available records, my lord, there's no affidavit from the department side, my lord.
Department. Right.
There's no affidavit from the department side.
Now, where do you got it? Is document?
So for compliance, when we process the file, my lord, we can find it out that her name was not actually sent by the headmaster of the school, and her case was not recommended by the district scrutiny committee. So that is why, my lord, ultimately we have filed this review
You
petition.
have to show your diligence in that despite your best effort, you could not produce the document during the course of hearing. But you have not filed your affidavit.
Yes, my lord. That is there, my lord. We have not filed our
Yeah.
affidavit. But fact remains that, my lord, as per our record, my lord, her name was not forwarded by the headmaster of the school. And
That is a different matter, but so far this review petition is concerned, the principle of review is well settled. There is a decision of Honorable Supreme Court in the case of Lily Thomas.
yes, my lord.
That subsequent decision of Supreme Court is that this delay has to be explained
Yes, my lord.
satisfactorily.
Yes.
But your case is that you have not filed your affidavit in opposition.
Affidavit is not there, my lord.
Where is your standing? Yes, Mr. Das.
The simple issue before, first of all, my lord, this is review, my lord. Your lordship is aware of the, my lord, the extent which we can go in a review.
Hmm.
Otherwise, the issue is very simple. The issue is whether she was at all working in that particular school or not. Whether there was any material of her working in that school from 2006 to 2010. The headmaster himself admitted that she was working. If she was working, then she is entitled to provincial. I'll just take 2-3 documents before your lordship, just like to place. Also, will kindly have a look at page 100. This was initial appointment order, 2006. Then 101, original 102 is the joining report. Hundred and six. 105 is the certificate issued by the headmaster that she joined on duty on 28/6/2006. Then 106 is a communication issued by the headmaster to the director. It says, most respectfully, in terms of your above referred order, you are hereby informed that Srimati Chandrama Devi has been working as the third assistant teacher in the school since 28/6/2006. In the form submitted in terms of Provincial Act 2011, her name was not furnished as third is arts teacher. However, in the form submitted under the amended Provincialization Act 2012, since there was provision for 3 arts teacher posts, her name was furnished as third arts stream teacher in the form submitted in the Office of the Inspector of Schools, Kamrup Metro. I'm not aware as to whether her name is present or absent in the report submitted by the District Scrutiny Committee, but she has been working since 2006 in our school as third arts stream teacher, and she has also worked as invigilator special duty in government BDS Deaf and Dumb School, Kahilipara in HSLC examination.
It is therefore prayed that she may be provincialized as third art stream teacher. Now, my lord will kindly have page 133. This is the amended provision by which, my lord, third arts teacher were brought in for provincialization. The amended act starts from, my lord, 129. Prior to that, there were only two. And relevant portion, page 133, three arts teacher. Now page initially the headmaster sent, in view of the previous act, two names. Thereafter, my lord, headmaster sent this one, page 139. This is the type copy that my learned friend, my lord, showed you also from the short while ago, page 52, which clearly incorporated the name of the petitioner. Original, if your lordships kindly see 141, page 141, assistant teacher BA BCom, serial number 3. Then my lord will kindly come to page 142. No, these are the documents based on which the order under review has been passed. Yes, my lord, one aspect I would like to show, my lord. Their whole case is that by bringing this new report of the inspector that my learned friend has shown, they want to say that I was not at all, I did not at all served in the school prior to 2010. That is their bone of contention. And the provincialization order issued by the government, by which all my colleagues were provincialized, my post had been kept withheld. I'll just show the provincialization order. My lord will kindly have. The format your lordship will find page 146. List C, withheld. And so far as the others are concerned, my lord, page 142, list A, serial number 2, all my colleagues, they were provincialized. Korobi Mishra, Kunjalata Rava. I was the number 3. And I had been placed in list C, withheld. Now, if your lordship kindly see the provincialization order. Raw. Prior to provincialization order, my lord will kindly have a look, page 150. Name of the school employees found eligible for provincialization under section 4(1) of the Act. Joint Director of Secondary Education, Kahlipara, endorsed it. My name is at serial number 2. I have been shown, my date of joining has been shown as 28/6/2006. Lordship's got my lord, page 150. Got it?
serial number 2. Then, my lord, another one, page 151.
Okay, these are part of the earlier.
Yes, true, my lord. My humble submission is that you are relying on a report from the inspector, which you have obtained after, my lord, order was passed in the writ petition, and you are disputing that I was never, I never worked in the school prior to 2010, basing on that report. Not what happened here, 2011, there were 2 posts, headmaster did not send my name. I was the 3rd one. After amendment, the headmaster sent the name. Headmaster himself gave the certificate that I worked there since 2006. My appointment letter is there. The resolution by which I was appointed was there. Then how can you disown your own document? These documents are not my creation. It's your document I am relying on. But what you are doing is that you are adopting a pick and choose method in accepting the document. So for the documents I have annexed in the writ petition, your document, you are saying, no, that document is doubtful. Because the headmaster, whether headmaster, I am not the custodian or I am not the authority to send my name for provincialization. What manner headmaster sends, whether one day before or consecutive dates, is for the headmaster to do. But the fact remained that I was all along there since the year 2006. So I am entitled for provincialization. The page 55 document which you are disputing, page 55, no, my lord, page. Yes, my lord, page 55 document, which they are disputing, is their own document, my lord. Signed by, my lord, headmaster. And headmaster himself said that I have forwarded the letter I have shown.
Sir, does now I am not on that point.
I'm sorry, my lord, I'm sorry. Your opposite.
So the point is that these documents upon which Mr. Attorney has relied upon.
Yes.
Page number 39, page number 44, page number 52. These documents these documents could not be furnished along with the affidavit in opposition. But the question is, the department has not filed affidavit in opposition.
Correct.
And the headmaster, affidavit of the headmaster speaks otherwise. He has
Yes.
not whispered any word about this document. Now the question is, okay, these documents are there, but where is the due diligence on the part of the review petitioner
Exactly.
for failing to produce those documents before the court at the time of hearing of the writ petition?
Correct. Correct.
But the problem is that they have not filed affidavit in opposition.
In fact, the decision basing on this document was already issued prior to the instant writ petition. They issued an impugn order relying on the contents of this document that she was not in service prior to 2000. I'll just place, my lord, you will have a look. Whether, my lord, this is a third round of litigation. In the second round of litigation, that issue was already over. The facts which they want to project now, that was already dealt with in the previous round of litigation. I'll just place once for a minute. Impugn order 2695. $164. My lord, kindly have page 164. This order was subsequently set aside by this honorable court. But what they have said in this, the contents are see the honorable High Court's order dated so and so, passed in so and so.
Also seen the documents particulars from provincialization of teaching and non-teaching staff of so and so, which were submitted by district level scrutiny committee to this directorate. The Honorable High Court passed order dated so and so in WBC so and directed the respondent number 2, Director of Secondary Education Assam, to examine the application of the petition in accordance with law and dispose of the same within a period of 1 month from the date of receipt of this order. Accordingly, a hearing was taken on so and so where the headmaster of Sabitri Bharali High School and the petitioner so and so was present. The headmaster and the petitioner stated that Srimati Sandrama Devi is working in the school since 28/6/2006, but the financial assistance was not given to her. The original staff pattern of Sabitri Bharali High School District Kamrup Metro was submitted by the district level scrutiny committee is not found in the office file number so and so. A photocopy of the staff pattern of the school has been found in the file where there is name of the petitioner as third assistant teacher arts. As the headmaster stated that no financial assistance was given to the petitioner and no original staff pattern has been found, the matter has been found doubtful and inquiry officer directed to the inspector of schools KDC Guwahati district to submit the original staff pattern which was submitted to the district level scrutiny committee for provincialization of service. The inspector of school KDC Guwahati has submitted both the copy of staff pattern submitted by the headmaster of the school, copy of staff pattern which submitted the district level scrutiny committee. From the above two staff pattern, it is found that there is no name of petitioner Sonora Devi as third assistant teacher. It is provided that the photocopy of the staff pattern which is in the office file is a false and manufactured document. So and so is rejected. So this was challenged before this honorable court, and this honorable court set aside, and I'll just place the order passed by this honorable court. Report order. Page, it starts from page 186. And relevant portion, my lord, will find page 188. After hearing the learned counsel for the parties, the impugn order dated passed by the DAC Assamese set aside and was, and the DAC Assamese directed to reconsider the case of the petitioners for provincialization of a service in accordance with the provisions of the Assam Venture Education Institution Provincialization Service Act 2011 and in terms of the order so after perusing the original records of the school in question, the resolution of the school managing committee and the attendance register of the school to verify whether the petitioner had worked as assistant teacher in the said school or not during the period from so and so to so and so, and on such verification if the petitioner is found to have worked in the said school as third assistant teacher, he shall be paid, he shall pass a fresh order regarding provincialization of service of the petitioner as assistant teacher in the said school. The petitioner shall submit a certified copy, so and so, so and so, so and so, so and so. So these documents were already there. Despite availability of documents, they did not produce those documents. Where is the ground for review? Now, after passing of the writ petition order of the order by the this honorable court, they will not caused an inquiry and ask for report, and basing on that report, can they go for can they seek for a review? In my humble submission, Milord, that is not error apparent or discovery of any new document to change the conclusion derived by this honorable court, Milord. In otherwise also, Milord, it's an admitted factual position that she worked there. Whether my name was in a particular format or not, that's a different thing altogether. But there is no dispute with regard to the fact their own document says I was there since 2006. There is a decision of Supreme Court where it is stated that the ground has to be explained for failing to produce those documents at the time of hearing of the due diligence. Yes, Milord. Correct. Can you produce that order? Or
Yes,
that
yes,
judgment?
Yes, I'll just place the order. Right now, I don't have, Milord. I'll place.
Then,
There is a recent judgment also, Milord, of the Supreme Court. There is a recent judgment.
okay. Let it be on Wednesday. Fine, Miss. Wednesday. Fine. But, Mr. Khatunier, the problem is that you have not filed your affidavit.
That I understand, my lord.
Better you should withdraw the petition, you consult your department. Then apprise this court on next day, Wednesday.
Yes, sir. That,
Otherwise, we will be compelled to file, or no, compelled to impose some cost while dismissing the petition.
Abla lordship.
Heard Mr. Khatunier, learned counsel for the petitioner, Mr. Das, learned counsel for the respondent number,
Sole respondent.
sole respondent. Heard in court, list the matter on Wednesday.
Sole respondent.
Full থাকিব চাগে, full আছে।
Full আছে, my lord. Respondent number
One.
one. I'm sorry.
Respondent
Respondent number one. Opposite party. No.
Okay.
But we will keep it as part. Huh?
Yes.
Yes. Highly.
May please, your lord. Lordship, there is a IA for delay, lordship. Delay of 218 days, lordship, for preparing this review application, lord. Notice may be issued, lord.
Where is the order?
Order, lordship, this is on 2024, lordship, passed by this honorable court, lordship.
That's all right. Where is the order?
This is my lord, separate review application, matter. So, page number, lordship, 44, lord. Page number 44, lord. And the RFA number 82/18, lord. In the suit, my lord, I'm the defendant number 3, lordship. But in the RFA, lordship, the respondent did not make my party, lordship, the petitioner. That's why we have prepared an SLB, lordship, before the Supreme Court. And the Honorable Supreme Court passed an order dated, lordship, on 25/7/2025 to approach this honorable court for file a appropriate review application, lordship. This is the Supreme Court order, lordship.
Page number?
Page number 27, lordship. Page number 27, annexure 1. Para number 3, lordship. The special leave petition stands dismissed as withdrawn with liberty to the petitioner who claims himself to be the defendant number 3 in the suit and who allegedly that he has inadvertently not arranged as a respondent in RFA number 82/18 to apply before the Honorable High Court for a review of the impugned judgment and order dated 20/12/2024. It is made clear that the even the petitioner fails in the review, his liberty to approach this court once again is reserved. The suit filed, I am the defendant number 3, but in the RFA, the petitioner did not made a party, lordship.
Pardon me, sir.
M does not.
Learned counsel for the applicant. This application under section 5 of the Petition Act is prepared by the applicant for condonation of delay of 118 days in preparing review petition. Filed under chapter 10 of the Guwahati High Court Code, Graduate Order 47, Rule 1 and 2 of the Code of Civil Procedure. For review of the judgment and order dated 21 2010-2024 in RFN number 82 of
2012, Lord. 2012, 2012.
2012-24. In RFN number 82 of 2018. Issue notice to the respondent opposite party, returnable in 4 weeks. Step be taken by registered post with AD and up to the usual process with this after 4 weeks.
Obliged, Lord.
May be the. My lord, the petitioner before your lordship is working in the, my lord, Indian Navy, and his wife deserted him and staying at her parental home, she submitted one representation claiming maintenance, my lord. And pursuant to that representation, my lord, my lord, monthly maintenance of rupees 10,312 has been granted, and accordingly she is receiving the same, staying at her parental home, and she vehemently refused to come back to the petitioner's house, my lord.
So, madam, you are appearing for respondent number
1, 2, and 3, your lordship.
2 and 3.
Yes, your lordship.
Who is for respondent number 1?
Union of India, your lordship. Your lordship, notice has already been issued on 6/6/2025.
As per Luazima report, my lord, the private respondent refused receiving the notice, my lord.
Your lordship, in this matter, notice has been issued, but I have not received the extra copies, your lordship.
That will be another.
So, for me, furnish a copy. to
My
me.
lord. Service may be, my lord, held completed.
Or. But you are representing a respondent number 1.
1, 2, and 3, your lordship.
So, for me, a learned counsel for the petitioner, learned CDC, for respondent number 123. As per order of the laws in my court, dated 38/8/2025. Service upon respondent number 4 deemed to have been completed. This is a list of matter for admission hearing on next day.
After 4 weeks, your
This
lordship.
after 4 weeks. Spoken submits that she has not been furnished with a copy of the petition. Mr. Borby undertakes to furnish a copy of the petition to Ms. Spoken during the course of the day.
My lord.
Oblige, your lordship.
This is a list of matter for admission hearing on.
My lord.
Oblige.
Obliged.
Made to your lordship. Lordship, as per the Lawazima order dated 22 September, service upon respondent number 7 has been complete, lordship. And the other respondents have not filed their affidavit till date, lordship.
We will file lordship, instruction not received lordship.
Lordship, a short date may be given because only 2 months period has been in the past, lordship.
Already?
Lordship, a short date may be given because already 2 months has been passed, lordship.
Third Miss,
Z Anjum, lordship.
learned counsel for the petitioner. Sir Sabi. Learned additional senior government advocate for respondent number
1, 3, 4, 5, 6, 8, and 9.
3, 4, 5, 6, 8, and 9.
9 Lord.
A Borua, learned counsel, appearing for Mr. C. Borua, as number 7. The Goswami submits that he will be granted some time to file with affidavit position. There is allowed versus unless the matter. After 2 weeks,
So Lordship, some more time to be granted.
okay. November,
Lordship, Lord. 17 November.
Your Lordship.
May I give that? My lord, in this case, my lord, earlier occasion, your lordship declined bail to the present petitioner, my lord, when the matter was under investigation. Now, my lord, this case has been charge sheeted, my lord. Therefore, he received one notice to appear before the court, my lord. But he is appearing erect. My lord, here in this case, my lord, there is a development in this case. Lordship, kindly have a look, page 13. Just, my lord, I may be allowed to, my lord, show the, my lord, basic relation of the parties. Page 13, this is FIR. Here, my lord, this informant Nur Muhammad is the son of, my lord, accused number 2. Accused number 2, my lord, Abdul Hashim. Nur Muhammad, son of Abdul Hashim, and accused number 2, Abdul Hashim. And rest all the, my lord, 3, 4, 5, 6, all are his, my lord, brothers, my lord, own brother. And accused number 1, who is allegedly main accused, my lord, who committed crime, he is, my lord, own uncle of accused informant, my lord. They are same family member, my lord. I am instructed in this case, my lord, actually, this accused number 1, Abdul Malik, my lord, he is now, my lord, 71 years old. He never married, my lord. And he is staying along with them, my lord. And in the meantime, my lord, his daughter, this alleged victim daughter, sometimes, my lord, occasionally as a same house, serving him, my lord, domestic help.
Okay, let notice go at this.
My lord, he will appear, my lord, he may be allowed to appear, my lord, and with some good observation, my lord, his bail may be considered, my lord, at this
No,
stage.
no. We have to issue notice to the.
Now, my lord, trial has begun, he has received notice, my lord, to appear,
Maybe, but these formalities are to be observed.
my lord.
Third Mr. A. Formuya, learned counsel for the applicant. Mr. K.K. Das, learned additional paper for the state respondent. This application under section 482 of the BNS of 2023 is prepared by the applicant for grant of TRS pay, who has been apprehending a list in connection with Rupohi Hathi's case number 414 of 2023 under section 376, 212, 576, 34 IPC, of the POCSO Act 2012. Mr. Formuya, learned counsel for the applicant submits that this is the second application.
Second one.
Second application, and the first one being AB number 4306 of 2023 was dismissed by this court by order dated 5/2/2024. Mr. Formuya further submits that this application is again filed on the ground that in the meantime investigation has already been completed and search has been filed, and the applicant has received notice from the court for appearance, and that the applicant will appear before the court and will stand trial, and therefore Mr. Formuya has contended to allow the pitch. Let notice be issued to the respondent number 2 by registered post with AD and also by usual to the office of the public prosecutor, Guwahati High Court. Guwahati High Court. That Mr. Das learned additional PT shall obtain a report in respect of. Can go with. In respect of. Service of notice upon respondent number 2 and place the same before the court on next day. In the meantime, registry shall call for the scanned copy of the record from the learned trial court.
My lord,
This is
district,
the matter after.
well, kindly, my lord, the court may be mentioned only from the court of additional session judge comes special judge Pokso Nagaon.
Nagaon.
Yes. Additional session judge comes special judge, comma, Pokso Nagaon.
This the
Obliging.
report. So Catonier,
Yes, what?
there was a direction to release the subsistence alone.
I have seen the order, my lord, and I have received an instruction also, my lord. For my instruction, my lord, her suspension was cancelled because she was terminated in the year 2014, my lord. Somehow she was continuing, my lord, and by mistake, she was again suspended in the year 2023. But when it comes to our knowledge that she has already been terminated, so this suspension order was cancelled. That instruction I have received. She is no longer an employee of the education department, madam, because her initial provincial order was cancelled and subsequently she was terminated. But somehow she was continuing. In fact, we have filed an affidavit to that effect, and regarding the order of this honorable court directing to pay the subsidy allowance, I have received an instruction requesting us to seek a review of that order since he has already been terminated from service, madam. In fact, in the present writ proceeding, my lord, we have not mentioned that her service was re-provincialized. That has not been mentioned in the present writ proceeding.
Our service has been.
Re-provincialized. Her provincialization order was cancelled subsequently. That has not been mentioned in the writ proceeding, my lord.
Yes,
Since
my
that
lord.
order is already exists, my lord, we will file an.
May it please your lordship. In, they have filed the affidavit in opposition, your lordship, and which is completely, this is a contradiction. That affidavit is all the documents, this is already pre-litigated. That I have stated in my writ petitions, your lordship. Your lordship may kindly come to the order of this honorable court, your lordship.
Page number.
Page number 43, and the operative part is at page number. All whatever documents they have enclosed in the affidavit opposition, these are already reflected in the order. Kindly, your lordship, move to page 51, paragraph number 14, 15, 16.
So, Mr. Katania, you file additional affidavit.
And another crucial aspect, already I have come just for the against the suspension order, Your Lordship. They have suspended me as per provision of Rule 6.1 of Assam Discipline and Appeal Rules 1964. Your Lordship, kindly come to Rule 6.1. It is already resolved, Your Lordship. That inquiry, Rule 6.1
No,
C.
Mr. Katania has submitted that suspension order has been withdrawn later.
In fact, in this order, the order referred by my learned friend, my lord, here also it is mentioned, paragraph 16, as per the service of the petitioner, Saira Khatun as junior citizen was not at all provincialized. It is a finding of this honorable court, my lord, it was not at all provincialized. Page 51, paragraph 16, last line, my lord. And the matter was referred to the educational tribunal.
Your Lordship, this order is a consolidated order, Your Lordship, in one single proceeding. And the petitioner in WPC, it is reflected clearly in paragraph 16, Your Lordship, 2553 of 2013. And WPC number 5325/2013. This petitioner has approached as per the direction of this honorable court for a trial settlement. And this petitioner has filed a complaint petition in the Learned District Judiciary, Your Lordship, that I have specifically stated in my additional affidavit as per the direction of this honorable court. Your Lordship, kindly come to my additional affidavit. Everything clear. It is supposed to be resolved in 2017, Your Lordship. It is very much clear. It was deprovincialized only for my alleged doubtful appointment. And that petitioner, the petitioner of WPC number 2553 and 5325/2013, he approached the learned court below that I have, and there is a findings, there is a doubtful that has been already those evidence were discovered of my doubtful appointment after the original evidence was presented, Your Lordship. It is clearly I have all the findings, the conclusive proof I have, but that was not brought before this honorable court in the earlier round of litigation, Your Lordship. That completely they have suppressed the material.
Okay, Mr. Katania, where is the withdrawal order of the suspension? Page number.
Withdrawal order, my lord, 2/4/2024. It is not in this affidavit, my lord. Page 88.
Only for
This is
dubious appointment. These are
page 88, my lord. In partial modification of this order dated so and so, the order of suspension of Srimati Saira Khatun of so and so school is hereby cancelled, whose provincialization of service was withdrawn by the office order number so and so as per interim order so and so, filed by so and so, till final disposal of the case, subsequently terminated by this office order number dated 19/12/2014, based on the report of the District Scrutiny Committee Thuguri, as per the Honorable High Court order dated so and so. This is the
Page number
88.
88.
Could be said to page number. More petition.
কোন একটা নেই। তো আপনার সাথে হবে
তোমার Paragraph kiman kola? 80.
88.
Yes.
So, madam, before this writ petition is filed, High order dated 2/4/2024, they have withdrawn the suspension order.
Only for the doubtful appointment. And when Mahmudul Islam, he approached the district judiciary, your lordship, the findings came out and it is unsubstantiated, your lordship. In respect of, and here another, because three of them have been suspended.
No. Madam, this writ petition is filed challenging the suspension order.
Yes, your
But
lord.
they have withdrawn the suspension order.
Yes, your
cancelled the
lordship.
suspension order.
Yes, your lordship.
So now where is your case?
My case is here, your lordship. Your lordship, come to my additional affidavit, your lordship.
No. This petition, you have challenged the suspension order
Yes, your lordship.
and also prayed for it's a subsistence law.
Yes, your lordship.
But they have subsequently filed Annexure 2A.
Yes,
page
your
number
lordship.
88. They have cancelled the earlier suspension order.
Yes, your lordship.
Now, where is your case?
Your lordship, that's because two of them, because in the same allegation of that school, the headmaster, one of the assistant teacher, and the petitioner, three of them were suspended in pursuance of that suspension order, which they have now suspend করেছে না এটা? জীবন?
No, madam, you see, the order which is challenged in this petition is cancelled. Now the suspension order is no longer there. Now where is your case?
এটা দিয়াই নাই withdraw কৰিছা? It's okay. No, yes. This is notified only in 2/4/2000 on the day when I have filed this writ petition, your lordship. Without notifying, your lordship.
No.
It is a legally challengeable issue, your lordship.
Madam, you have filed the writ petition on 5th of April 2024.
No, I have filed on date of filing, yes, it is the acknowledgement, 2/4/24, your lordship, this is the acknowledgement. Date of filing is 2/4 and date of registration is 6/4. Date of filing is 2/4/24. This
So,
is,
in this writ petition. the
And they
petition
have-
mention-
they have, this corrigendum is issued at at 5 after 5 p.m.
No.
This is the
This
sequence, your lordship.
corrigendum was issued on 2nd of April 2024.
Yes, your lordship.
And the writ petition was filed on 5 April 2024, 5th of April 2024.
But I have filed on Already I have served a copy to the respective
No.
state respondents.
Here the.
This is the
they have-
sequence, your lordship. They
Oh.
have not notified, they have not issued me that corrigendum. It is a legally challenging issue, your lordship. It is a legally challenging issue.
No, no.
That is only the sequence, your lordship.
They have marked a copy of the corrigendum to you.
No, it was not in my hand. It was, they have marked, but not at all received. They have marked.
Yes.
This is the sequence, your lordship.
Right.
This is your lordship's concern. They have issued at 6 p.m., your lordship, after 6 p.m. It is not the office hours also. It is not at all the office hours also.
Pardon?
It is not the office hour, your lordship. And it is very much clear in the acknowledgement.
No. There is no bar in issuing corrigendum after the office hour.
Okay, I leave it. But I have filed on 2/4/2024.
But you see, if it is writ petition here, it is mentioned filed on the 5th of April 2024 by the filing assistant.
This is the explanation. अपने देखो जोक्स देखो एक मिनट ये देखो I don't know, but it is how come this is it's not my record. It is the record of the High Court. It's a print record of the High Court. All Talabana, all others. Acceptance notice. এইবিলাকে তো 2 নম্বৰী কৰে ন গভৰ্ণমেণ্টে
So the writ petition was registered on 6/4/2024.
It is not my concern. I have filed on 2/4/2000.
Maybe prior to registration of the writ petition, they have cancelled the order. Now
was-
you tell me, where is your case?
It was not served upon me. That is the important. It was not served upon me, your lordship. It is a legally challengeable issue.
Maybe, but the order challenge in this petition is no longer there. So this petition, according to this court, become infractious. You challenge the termination order by which they have terminated you.
The other aspect, the other factual part is pending before the education tribunal as per the direction. Because in the order, it was says it's totally a disputed question of fact. Then again, they came with this, they released my salary. That is the important. Yes, I have in my affidavit in opposition, in my additional affidavit. Yes, they have released my salary. I am serving. It is clearly. They have filed their affidavit. Your lordship, come to the additional affidavit, your lordship.
Is number
they have already filed the additional affidavit at page, in the additional affidavit, annexure 27, page number 159. The inspector of school has filed a written statement on behalf of all the respondents.
Page number?
Page number, the order of the inspector of school is page number 159, your lordship. And their written statement at annexure 28, page number 161, 8 March 2019. Yes, I'm fully complied with the order of this honorable court, your lordship. And immediate after, within the time limit, I have approached the educational tribunal. They have filed their written statement on behalf of all the respondents, respected respondents.
You show me the document that you have received salary after.
Yes, yes, yes.
Where?
Your lordship, at page page 105, annexure 15, your lordship, till your lordship, at page 105, your lordship, annexure 15. March 2023. In this regard, there is, your lordship, kindly move to page in my origin application, your lordship. Kindly move to the honorable tribunal's order, your lordship. At page, before coming to this point of salary, your lordship, kindly come to page 53 of my original petition, annexure 9, your lordship. This is the tribunal order. It was with the consent of both the parties, the petition is allowed. After filing, they have completed their part, respected state respondents, even
Page number?
page number 53, your lordship, annexure 9.
So, annexure 9, you have withdrawn the petition.
Yes, withdraw the petition, and thereafter I have started, it is the opening up of, they have two, here, your lordship, see, your lordship. Yes, it was on order passed on 22, and their written statement they have filed. They have filed on yes, with the consent of, I have withdrawn due to some procedural irregularities. I have withdrawn, and I have, it is the opening.
Thereafter, what happened?
Thereafter, they have released my salary. It was in December 22, your lordship.
No,
It was in December 22, and they have released my salary on March 23, your lordship.
You show me the document of where you have received the salary.
It is at page in additional affidavit. It is at page 105, your lordship, of additional affidavit, annexure 15.
This is only bill for.
At page 126, I have received. At page 126, your lordship, of my additional affidavit. Thirteen 4/2023 for the month of March. 3/5/2023 for the month of April and 13/6/2023 for the month of May, Your Lordship. And suddenly they stopped my salary.
The Khatunier,
Yes,
how you have paid the salary then?
that is, my lord, that I have to inquire because apparently, my lord, her services was deprovincialized. Order was there, my lord.
That is pre-litigated, Your Lordship. They have repeated.
No, please. Yes.
Somehow, my lord, he was continuing. It is there, my lord, he was
What
continuing.
somehow?
Means,
That is, my lord.
What somehow? Everything is recorded. It is stopped by this honorable court.
Madam, please sit down, please. Yes.
So somehow she was continuing. And when the
You are
entity,
paying salary
sorry, my lord.
and you are paying
Yes, my lord.
salary.
Yes, my lord. She was getting salary. I have seen the document, my lord. She was getting salary. So when this writ petition was filed, during that time, my lord, it was found that her services were deprovincialized in the year 2014. So we have issued an order that since her service has already been deprovincialized and she was terminated, therefore the order by which she was suspended, that was withdrawn, my lord. Regarding the present writ petition, my lord, regarding her suspension and payment of subsistence allowance, since the order of suspension is no longer exist, there is no cause of action as regards this writ petition is concerned. Regarding either why she was getting salary or now it was stopped, that is separate cause of action, my lord. In any case, in this writ petition, she cannot pay for salary since there was no prayer for payment of salary.
And where is the deprovincialization order?
That is page 18. Page 87, my lord.
And this writ petition was a response of WPC number 2553 of 2013.
Yes, my lord. In that writ petition, my lord, it was observed that the services of the petitioner has not been provincialized. That's shown to your lordship, paragraph 16, page 51. Page 51, paragraph 16.
And thereafter the matter was referred to tribunal.
Tribunal, my lord.
And tribunal, before tribunal,
They
they
have-
have withdrawn the petition.
No, before that, they have filed their written statement, Your Lordship.
That is our duty, my lord.
Yes.
They have filed the case. we have
Okay,
filed it.
yes. And it is my opening, yes. They have, immediately after the withdrawal of my, of the petition, they have start paying my salary. It is my opening step in the appropriate tribunal.
No,
And
where is their written statement in the
yes, Your Lordship,
tribunal?
yes.
Page number?
Page number, just clearly, everything clearly they have admitted, affirm, it is affirm, Your Lordship. At page page 161, Annexure 28, Your Lordship. That was filed on 8 March 2019. And
Where they have admitted?
at paragraph 4, Your Lordship, at page 162.
Hmm.
May I be pleased to read over? It was legally provincialized. After observing all the necessary formalities and procedures as required under the law.
Sir, Attorney, you see page number
This is a-
162,
well,
paragraph 4.
Kindly come to page 161. It's an written statement filed by the school managing committee,
Yes, on behalf of,
not by the government.
on behalf of, yes.
School managing committee cannot.
After
file on-
RTI,
on behalf-
after RTI, by filing RTI, Your Lordships, I have got the Parvez comments. I filed my RTI petition also.
No, who constitute the school management committee? The government?
Maybe, my lord, but
How maybe?
my lord, the school managing committee cannot file affidavit on behalf of the inspector of school, on behalf of the director of secondary education, on behalf of the
No,
secretary of government.
if they are implicated as party, they can file it.
No, they cannot file it because we are the authority. They are not governmental. They are not governmental
No,
authority, my
Mr.
lord.
Antonia, today school management committee filed one review application here.
They can file, but they cannot file on our behalf, my lord.
No,
It is on their behalf they file, my lord.
No, on their own they have filed.
Yes,
it,
my lord, but they cannot file on our behalf, my lord. That is not our stand that they have, the petitioner was legally appointed. That is not our stand. That is the stand of the school managing committee, my lord. They are not governmental body, my lord.
So,
Here, Your Lordship, another, in the earlier round of
no,
litigation.
Madam, you see, in this petition, you have challenged the suspension order.
Suspension order, Your Lordship.
And also you prayed for releasing the subsistence alone.
Yes, Your Lordship. And
Now-
they
now
are
the
paying me
question is-
salary.
Now the question is, the order you have challenged here is cancelled by them by issuing one corrigendum.
Yes, that is only disputed. This corrigendum has not served upon me. It was not notified. And on the day when I have came to this honorable court by filing this writ petition, they have filed this corrigendum, Your Lordship. That is a very crucial point I am bringing before Your Lordships.
No, that's all right, but the question is the order is no longer in existence now. And
Your Lordship,
this,
Your Lordship.
petition, this writ petition was registered only on 6th of April. They have issued the order on 4th of April. So, before filing up the petition, they have terminated, they have cancelled the order. So since the order is not there, this petition according to this court become infractuous.
Now, why they have paid my salary? Why they have paid my salary? And even it is permanently retained. The post also, I have stated in my post is permanently retained.
No, that may be a subject matter in a different petition, but here the order challenge is no longer there.
No, there is a very crucial point, Your Lordship. Because of that suspension order, on the same allegations, three persons were suspended based on that, so that which I have challenged before Your Lordship. And two of them based on the same conclusive finding of the district judiciary, Your Lordship. Two of them have.
No, not, where is the conclusive finding? You have written the application there from the tribunal.
Thereafter, they have filed this, they have paid me salary, Your Lordship. They paid me
No,
salary.
So that's all right, but now the challenge order is no longer there.
But here, Your Lordships, you kindly come to the same page 56, Your Lordship, 156 of the additional affidavit, Annexure 25. Annexure 25, page 156, Your Lordship.
Yes.
Here, may I be pleased to read over?
No, not necessary. You see, this order is no longer there. By issuing the corrigendum, they have cancelled the order.
But on the same allegation, my question is only that before Your Lordship, only on the same allegations. It was Your Lordship kindly.
Maybe they have, since they have cancelled
Yes,
the
that is a
order.
conclusive order, Your Lordship. There is a conclusive order. There is a conclusive order of the London District Judiciary. And based on that FSL report, Your Lordship.
No, if you have withdrawn the appeal filed before the tribunal, then how can the tribunal pass conclusive order?
I have
Madam, you say you obtain instruction from your client that the suspension order has been cancelled by the respondent authorities. Now what to do? The other matters we cannot
based on the
get in this petition.
yes, here sometime may be given.
Okay.
Questions. Date may be fixed also, Your Lordship.
Art. It's Puja Lord at the respondent, the elementary, secondary. Third in part, list the matter on.
Silence. More silence. More silence.
Wait, please, Your Lordship, kindly peruse the last order dated 16/9/2025, Lordship. Passed by Your Lordship. The case of the petitioner ought to be placed before the Committee of Finance Department and Department of School Education for consideration of the matter of provincialization, which is scheduled to be held on 20/09/2025.
Lordship, I have received my instructions on 10th of this month, Your Lordship.
Pardon?
I have received my instructions, Your Lordship. A meeting was held on 25th of September, Your Lordship, where it has stated that some reports are yet to be received of the SMC, Your Lordship. So when the report will be received by the department, and then we can go to the proceeding for the provincialization, Your Lordship.
What report you were supposed to get from?
There are some records,
SMC.
Your Lordship, which has to be received from the SMC, Your Lordship,
What report?
regarding the provincialize of the service of the petitioner, Your Lordship.
No, whether the SMC has recommended his name.
That's the thing, Your Lordship, we need to receive.
Other services are provincialized, Lordship. Only mine was left out, Lordship.
So on 28th September 2025, no meeting was held.
No, Your Lordship, the meeting was held on 25th, Your Lordship.
And
And a
today,
communications letter
today
has
is
been
13th
sent
of-
on,
no, today is 13th of October.
yes, Your
And
Lordship.
till that, you have not received the report.
No,
from
Your
the
Lordship.
SMC.
A letter has been sent on 10th of this month, Your Lordship,
Regarding,
regarding the communications letter, Your Lordship, for receiving of some record from the school, Your Lordship. A meeting was held on 25th of last month. So a letter has been sent from a director office to the president, Your Lordship,
regarding,
regarding to send some documents of the petitioner, Your Lordship, for the provincial.
where is that letter? You saw me?
Your Lordship.
No, what is the result of the meeting?
Lordship.
So that is the only result which I have received, Your Lordship, the instructions that a meeting was held between the department and the finance department, Your Lordship. And some documents are yet to be received from the school, Your Lordship.
So whether the matter was placed before the SMC or not,
So that, Lordship, I don't have the instructions, Your Lordship.
then what instruction you have?
This is the only instructions I have received, Your Lordship, today.
Just what? Please. Some other rate petitions are also pending here.
Lordship,
Some other rate petitions are also pending here.
Lordship, other
Thing
petitions are
also-
disposed of, Lordship,
Dispose of.
Lordship.
When?
Lordship, mine is 5614, Lordship.
Hmm,
Yes.
4477 of 2022.
4477, 2022.
Hmm.
Hmm.
Dispose of. Lordship, it was disposed of 4477, 2020.
No, some other persons have also filed a rate petition opposing provincialization of your service.
Yes, respondent authority filed that 4477 of 2022, Lordship.
Respondent,
4477, Lordship, that is filed by one Haji Amsar Ali Mukhtar, Lordship, which is at page 59 of Annexure I, Lordship. Page 59.
page number
59, Lordship, Annexure I. He was the president of the governing body, Lordship.
this was a dispose of.
Lordship, this was disposed of, and wherefrom he clearly specifies the fact that, Lordship, the state level scrutiny committee has recommended the name of the petitioner. It starts from page 61, Your Lordship.
Which is the relevant paragraph.
Lordship, page 61, Lordship.
Relevant paragraph.
Page 62, Lordship.
Paragraph number 4, Your Lordship.
From 4, Lordship.
So what remain to be examined then?
Lordship.
This matter has already been disposed of.
Yes, Your Lordship.
Lordship. It was disposed of on 18/7, Lordship. 2022, Lordship.
So they have been asked to file appeal.
Lordship.
What is
Yeah.
the question of conflict of order? Heard, Mr.
P. Bodley, Lordship.
Report learned counsel for the petitioner and Ms. Dharamti, learned standing counsel for the respondent, Secretary to the Department. Person to order dated 16/9/2025, Ms. Dharamti has produced one letter of the Deputy Secretary to the Jobs of Assam Department of School Education dated 9/10/2025. Wherein it is stated that a meeting was held. No, a joint sitting of Finance Department and Department of School Education was held to examine the case of the petitioner. To examine the case of the petitioner. And now the department is examining the pendency of the parallel rate petition opposing the provincialization and the other linked orders of the court to avoid conflict while disposing of the matter in compliance to the order of this court. But Mr. Bordoloi, learned counsel for the petitioner, has pointed out to an order passed by this court in WPC number 4477 of 2022, filed by one Haji Amsur Ali Mukhtar Girls Secondary School and another. And Mustafa Sahidul Islam. Sahidul Islam. And the said writ petition has already been disposed of by this court on 18/7/2022. And the said order is annexed with the petition as Annexer 1.
I, Lordship.
Annexer I
Lordship.
at page number 59 of the petition. And a perusal of the said order dated 18/7/2022 indicates that no writ petition is pending now. The writ petition number 4477 of 2022 has already been disposed of. And as such, there is no chance of any conflicting decision. Conflicting decision. And under such circumstances, there is no bar in provincialization of the service of the petitioner.
Okay.
Service of the petition. And also there is no scope of any conflicting decision by the respondent authority. In view of above, it is provided that Mr. Ramli shall further obtain further instruction in respect of the progress of the matter or next week. This is a list the matter on next week.
Lordship, 22, Lordship. 22, Lordship. 23rd, Lordship. Lordship.
The letter produced before the court today shall be marked as Annexer Y and be taken to the record. Mr. Ramli, you see, no writ petition is pending now.
Yes,
There is no scope of any conflicting decision. So you ask them to pass necessary order.
Lordship.
If the SMC has already approved it.
yes, sir.
Approval has already been made, Lordship. Approval has already been made, Lordship.
Oh.
Let them submit that thing, because in the order, in the last order, it also reflects that fact, Lordship.
Grace shall reflect the name of Ramli in the cause list.
Oblige,